Most of all, I'm sorry to Mags and Paul. I would never intentionally do anything to hurt either one of them.
Most of all, I'm sorry to Mags and Paul. I would never intentionally do anything to hurt either one of them. Hold that sentence in your mind for a moment, because everything that follows depends on what you believe about the man who said it. A jury heard those words, watched the tears, watched the trembling hands, and decided he was lying.
The nation watched a blubbering Alex Murdaugh on the witness stand during his double murder trial. The jury did not believe what he was saying and convicted him of shooting and killing his wife Maggie and his son Paul. But then the convictions were overturned, back to square one, and Alex Murdaugh is getting a brand new trial. But this time it looks like the defense has a new...
They convicted him of murdering his wife and his son. And then, months later, a court took the conviction away and handed it back to him, unused, like a gift returned to sender. Back to square one, a new trial, a new judge, and this time, a different defense. One that does not ask the jury to believe a grieving husband. It asks them to believe a fingernail. This is the case of Alex Murdaugh, and what follows is not a story about whether he is guilty. It is a story about what happens when a legal team gets a second chance to do what they failed to do the first time, and about the quiet procedural battle being fought right now over 6 microscopic strands of genetic material.
Welcome back to the low country of South Carolina. I still can't believe, I got to pinch myself that we're talking about this again, but it's for real. Like, the convictions were overturned. So now we're going to talk about the new trial. Well, during that first trial, Alex Murdaugh told his story, right? It was the biggest part of the case.
Alex Murdaugh, husband and father, was a member of a powerful legal dynasty in that same county. A 4th-generation lawyer whose family had effectively run the local solicitor's office for nearly a century. At his first trial, the prosecution did not need much theater. They had financial records showing he had spent years defrauding his own clients and his own law partners, stealing from people who trusted him with their settlements.
The guy spent his career defrauding clients and his own business partners. All right, think about that. And all that came out. So his testimony that did not work was basically, ladies and gentlemen, yes, believe me when I tell you I'm sorry for lying to everyone and stealing their money. But believe me now, yeah, I lied to my client.
They had a timeline, and they had his testimony. Testimony in which he took the stand, wept, apologized, and asked the jury to believe that a man capable of years of calculated financial deception was, on this one subject, telling the truth. The jury did not buy it. It did not work. They convicted him. That conviction is gone now, set aside on a procedural issue unrelated to guilt or innocence. And so the case resets. Not the facts. The facts remain exactly what they were, but the strategy. A defense team that watched their client's own testimony fail spectacularly is not going to put him back on that stand and ask the jury to feel something. This time, the defense wants the jury to look somewhere else entirely.
Okay. Defense, different job. It's to represent the defendant and try anything and everything within the legal world, right, and the ethical legal world to raise a doubt, wherever that may come from. So in this case, it seems like there's going to be a lot of focus on Maggie Murdaugh and the DNA under her.
Under Maggie Murdaugh's left fingernail, forensic analysts recovered male DNA. It was not from her husband. It was not from her son. Both men were excluded as contributors during testing performed before the first trial.
Strategy, trying to identify an actual alternative suspect.
They did find a unknown male DNA who was not related to any Murdaugh or any of Maggie's family under her fingernail.
So is this DNA the key to an acquittal? It was part of the first trial.
Were Paul and Alec Murdaugh excluded as contributors?
Yes.
That detail is important enough to repeat slowly. This is not new evidence manufactured for round 2. It existed the entire time. It sat inside a sealed evidence envelope while the first trial unfolded around it, mentioned briefly, cross-examined briefly, and then left alone. Nobody chased it down. Nobody asked the question that the defense is now asking with real urgency. Whose DNA is it? That is your open loop.
But second time around, it looks like the defense is going to use this DNA as a potential centerpiece of their case. Is there reasonable doubt under Maggie's fingernails? They lost the first trial, but with a new trial comes some new strategy, but not necessarily new evidence, but some new technology for that old evidence.
Hold on to it, because the answer, if there is one, may not arrive for a long time, and the path toward finding it is where this entire case now lives. Here is the legal landscape you need before anything else makes sense. A criminal trial has two sides with two different jobs. A prosecutor's obligation, if they are doing the job ethically, is to present the truth as the evidence supports it and let the jury reach a verdict based on that full picture. A defense attorney's obligation is different. It is to test the state's case at every seam, to raise reasonable doubt wherever the evidence allows it, using every legal and ethical tool available. Reasonable doubt does not require proving someone else did it. It only requires showing that the story the prosecution is telling has a hole in it large enough for uncertainty to live inside. The defense believes that hole is shaped like a fingernail. At the first trial, this DNA was treated almost as a footnote.
Jim, can we talk about new evidence? I know last week you mentioned DNA evidence under Maggie's fingernails, essentially connected to a nail. Can we go into that a little bit more and how that will play a factor in this year's trial?
Well, we pointed out during the last trial that they did find unknown male DNA who's not related to any Murdaugh or any of Maggie's family under her fingernail. That was, not really followed up on. We asked that they follow up on that before the last trial. We don't have possession of that DNA, so we can't do anything with it. We can perhaps, with a new case, back to...
The defense raised it once, briefly, and the moment passed without consequence. It did not resonate. An unidentified man's DNA, floating in the record with no name attached to it, is a hard thing for a jury to feel anything about. An unknown person is not a suspect. An unknown person is just a gap. So what changed? Technology changed. In 2021, when these murders occurred, a forensic technique called investigative genetic genealogy, the method that takes a small DNA sample and searches consumer ancestry databases to identify relatives and eventually the source, was still in its early stages. 5 years later, it has matured into one of the most consequential tools in modern criminal investigation. It is the same method that identified the man responsible for the killings of 4 University of Idaho students, after a national database search came back empty and a private lab traced the sample through a relative's ancestry test instead.
Let's watch some more.
At the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberg. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have...
That case is not abstract to this defense team. They cited it directly in court because it proves the technology works, and because it proves something else just as important. that this kind of DNA analysis is not exclusively a prosecutor's tool. When DNA testing first became viable decades ago, it was the defense bar and the Innocence Project who used it most aggressively, clearing wrongfully convicted people by the dozens. DNA cuts in both directions. It can implicate, it can also clear. The defense wants the chance to find out which one applies here. So picture the room. A new judge, recently appointed after the state's chief justice ordered a replacement once the case was formally sent back down.
Well, it'll be Chief Justice Kittredge issued an order last week saying he's going to appoint a new judge once the remediator goes down. And that'll be one of the things that we will present to a new judge asking for that relief. Whether he or she will do it remains to be seen.
Okay.
A defense attorney standing at the podium explaining calmly and specifically why 6-year-old genetic evidence deserves a second look, using technology that simply did not exist in usable form when the murders happened.
And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021.
And a prosecution that is not exactly resisting the request, but is not exactly racing to help it along either. That tension is the entire engine of this hearing, and it is worth sitting with for a moment before we go further. Ask yourself honestly, if you were the prosecutor in this case, confident in the evidence you already had, would you welcome a new round of testing on a piece of evidence you had once dismissed as unimportant? Or would you quietly hope the question never got asked twice? The defense made its request plainly. They want the unidentified sample sent to a private laboratory in Houston, Texas, the same lab that solved the Idaho case, for advanced genetic genealogy testing. The state's crime lab uses an older method called STR analysis, which compares
samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that, and so, you know, we're going to have to see what the lab says. They've asked me to get information from SLED as to, you know, they like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd asked Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab.
It is the difference between checking 20 boxes on a form and reading the entire document. It is slower, it is more expensive, and it is, according to the defense, the only realistic way to ever put a name to the DNA under Maggie Murdaugh's fingernail. The judge did not say no. He also did not say yes. What he said was more interesting than either answer, and it tells you almost everything about how this next phase of the case is going to be fought. Give me a timeline.
Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
That was the substance of it. Before granting anything, the judge wanted to know exactly how long the testing would take, whether a usable sample even existed in sufficient quantity to test, and what would happen if it did not. No urgency performed for the cameras, no dramatic gavel, just a measured demand for specificity before a single additional resource gets spent. It is a small moment. It is also, in its own quiet way, the most important moment in the hearing, because it is the sound of a court refusing to be rushed by either side, refusing to grant a request on momentum alone, and insisting that even something this technical earn its place on the record one verified fact at a time. And then came the part of the hearing that, frankly, almost wrote itself. The prosecution's position was simple. Before anything moves forward, give us a name, a specific contact at the private lab who can answer technical questions. The defense's position was just as simple and just as immovable. You give us a name first, and we will have our lab reach out to yours.
What's the name? And I'm happy to have SLED reach out and talk to them about what their
Hold it right there for a second. It's so funny, right? Like, give them a name. Well, why don't they give us a name? You know, this is the way lawyers are. I'm a lawyer, I know. Like, you got to be, all right, well, give us the name of the guy to contact. No, you give us the name of the person you want us to contact, and I'll give it to my guy to contact your guy.
Two attorneys standing a few feet apart in the same courtroom, each waiting for the other to blink over the exchange of a phone number. It is the kind of moment that never makes the highlight reel of a true crime documentary. And it is exactly the kind of moment this channel exists to notice. Because underneath the absurdity of it is something true about how litigation actually works. Position is currency. Even a business card can become a bargaining chip when neither side wants to be the one perceived as asking first. This is where the case currently rests, and here is where things get genuinely interesting. Because the recess in this hearing is not a pause in the action, it is the action. The judge has not ruled on whether the testing happens. He has asked for a timeline and confirmation that a viable sample exists before he will commit to anything further. Somewhere in a lab, possibly right now, someone is examining 6-year-old genetic material and deciding whether there is enough of it left to even attempt this. If there is not, the defense's entire centerpiece evaporates before testing even begins. If there is, the case proceeds into territory neither side can fully predict. The defense is gambling that an unknown name will be more powerful in front of a jury than an unknown shadow. But unknowns are unpredictable for a reason, and that is the real risk sitting underneath this entire strategy. The part defense counsel did not say out loud, but surely understands. If genetic genealogy traces this sample back to someone with an innocent explanation, a first responder, a member of the original investigative team, anyone with lawful contact with the scene, the defense will have spent months and real money manufacturing exactly the kind of dead end that helps no one but the prosecution.
Be careful, because it might lead to an absolute dead end. So it is kind of risky what the defense is doing here. Going out and doing what we usually see prosecutors do, which is take this DNA and try to figure out who's connected to it to see what it leads to. And if it leads to a dead end, then it's very problematic. But there's always the chance that it leads to something else. And for those of you out there who believe that Alex Murdaugh may be innocent and wrongfully accused in all of this, maybe it leads to the killer, right? I watched the first trial. I didn't come to that conclusion. I was not impacted by the court clerk.
There is no guarantee the trail leads anywhere useful at all. So why take that risk? Because the alternative is worse. The alternative is the first trial repeated. A defendant on the stand asking a jury to extend trust to a man who spent a career methodically betraying it. That argument already lost once, in this same county, in front of jurors who knew this family. The defense is not going to make the same bet twice. Now slow down, because this is the part of the case that actually matters more than anyone's testing schedule. The defense's own theory contains a detail worth sitting with carefully. Maggie Murdaugh's cell phone was missing from the crime scene. A shell casing from the weapon used to kill her was recovered close to her body. If those two facts are connected, if whoever fired that weapon also handled that phone, then a transfer of DNA from hand to nail becomes suddenly not a stray footnote in the forensic record. It becomes the outline of a second person who was there. Not speculation invented for a script, a connection drawn directly from sworn argument made in open court by the defendant's own attorney to a sitting judge.
I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them.
Say it plainly, once, without embellishment. Someone's DNA is under that fingernail. It is not Alex Murdaugh's. It is not Paul's. For 5 years, nobody asked hard enough whose it was. Now, finally, someone is asking. Whether the answer changes anything, whether it points toward an alternate suspect, or toward an explanation entirely unrelated to the murders, nobody yet knows, including, very likely, the people asking the question. That is the case as it stands. Not resolved. Not close to resolved. A request, a recess, and a courtroom standoff over a phone number, with the actual answer sitting somewhere inside a laboratory, waiting on technology to catch up to a question that has been sitting in an evidence file since 2021. Here is what this case can actually teach you, and it has nothing to do with whether you ever sit on a jury for a murder trial. It is about what happens long after a case appears finished. Evidence does not expire. A detail dismissed as unimportant at one trial can become the entire foundation of the next, if the science around it eventually catches up. If you are ever a party to litigation, civil or criminal, large or small, do not assume that what gets glossed over today stays buried forever. Ask what exists in the file that nobody followed up on. Sometimes the most consequential piece of evidence in a case is not the one everyone is arguing about. It is the one sitting quietly in an envelope, waiting for someone to finally ask the right question.
Okay. You read into what Jim Griffin said there. Murdaugh's attorney. Her cell phone is taken. Shell casing under her body. The killer was there with her. Did that DNA transfer when he took the cell phone? Was it in her hand? How did all that take place? So you can see where they're going with all of this. And they're going to need another expert to try to recreate how that DNA could have been transferred.
And in a courtroom, that is usually how the real story begins. Not with a verdict, but with a single unanswered question that somebody finally decided to take seriously.